Welcome, everyone, to the Team Wealth Live broadcast. This is Matt Sorensen, excited for today because we have some news from the federal courts last week about the Corporate Transparency Act. We're going to be digging into it today. I'm going to go over what this case means, what the Corporate Transparency Act is, which every small business owner, whether you have an LLC or corporation, needs to know about this. Then we're going to go into strategies you're going to need to know. And do you need to comply with this? Should you wait on the court's decision? It's a mess right now. We're going to dive into it, but we're going to let some people join here. So just bear with me for a moment. I want to go over what we're trying to do here with Team Wealth. What I'm trying to do is help people build wealth on your own. You do not need to hire a financial advisor. You can. You do not need some get-rich-quick scheme. Maybe that works. But what we're trying to do here with Team Wealth is teach practical wealth-building strategies that I've seen work. My 10,000 hours I've spent with clients, business owners, real estate investors that have had success, my own personal experiences about how you can build wealth. Now, one of those things is small business, owning a small business, buying rental real estate, and anyone in that realm, you need to know about this. The Corporate Transparency Act, what we're talking about today, is a critical requirement you have to comply with, but it has just been ruled unconstitutional. So I'm going to dive into that. That's the topic for today. Now, we're going to be here live every Monday talking about some topic around wealth building. And we're going to be doing open forum too, or we're going to be going over questions and people's situations as well. But for now, we're going to be sticking to it every Monday at noon Pacific time. We'll be here. We hope you are too, talking about how to build and take control of your wealth. All right, now just going to give it a minute or two as we get people coming in. And then I'm going to fire this off here and give it an official start. But thanks everyone who's on right now. Hang in there. If you've got questions, make sure you throw them in to the chat. No matter what format you're on, whether you're on YouTube, Facebook, Instagram, we're live on a couple places right now. And then this does get posted to my YouTube channel. We'll also be putting it in the private Facebook group. If you're listening right now and you haven't joined the private Facebook group, we're going to be very active in this area. It's a great place to meet and network with other people trying to build wealth. We're going to be building a community of like-minded people trying to build and grow their wealth. So make sure you get over to the private Facebook group for Team Wealth Building with Matt Sorensen, and we'll be dropping in the link for that as well today. All right, I got Tristan here in the studio. He's going to be reading off some of the questions as they come in. I already have about 8 or 9 of them that came in before the show of people's questions about Corporate Transparency Act. In this case, I'll be hitting those as well. But if you have questions as we're diving into the content, just let me know. All right, we're ready to go. Okay. This is a critical case that came out from the Alabama federal court last week, ruling the Corporate Transparency Act is unconstitutional. Now, the Corporate Transparency Act is the biggest law that has ever passed affecting owners of LLCs and corporations in my lifetime. I've been a lawyer for almost 20 years now. This is the biggest change at the federal government level for LLCs and corporations. It was known as the Corporate Transparency Act. Now, if you've never heard of this, if you've been living under a rock and you haven't been paying attention to the legal requirements for any of you with LLCs or corporations, this is big. You need to know about this. I've shot other videos on it. Make sure you click the link here. I've got other content on it. We'll be dropping that in the chat about what the heck the Corporate Transparency Act is. I'm going to break that down a little bit today as well. But essentially what that is it's a new federal government law that requires owners of LLCs or corporations. I don't care if your LLC doesn't make any money or it's a loss, it's got rental properties. We don't care. The IRS still wants to know about it. And this is a government agency actually called FinCEN. It's another division of the Department of Treasury. It's actually not the IRS. It's its own division in the Department of Treasury called FinCEN. Now, what this does is it requires anyone who owns an LLC or corporation to disclose the ownership, anyone who owns 25% or more, or anyone who has substantial control in the corporation or LLC, like the manager or the president. Those people have to be disclosed to this federal government agency known as FinCEN. Now, the policy reason for this and why this law was passed was to combat money laundering and other criminal acts that could happen in a corporation or LLC. There's a belief from the government that people use LLCs and corporations to hide shady business activity, money laundering, drug trafficking, other things like that that are criminal enterprises. And so they want those owners of these businesses, all of us, the good people and the so-called criminals they're trying to chase with this, to file a disclosure document known as a BOI report. It's called the Business Owners Information Report to FinCEN. Now, this Business Owner Information Report must disclose everyone who owns 25% or more. You must identify their name, their date of birth, their address, and provide a government issued ID, whether that's a driver's license or a passport or some federal government, some foreign government passport or visa. So you have to provide those information for everyone that's an owner or has substantial control of a corporation. Now, that law passed back in 2020, 2021, but it didn't go in effect until this year. So now in 2024, this law has gone into effect and people are required now to file this. Now, we've helped thousands of clients already in our law firm and in Main Street Business Services, our company compliance business. We've already filed thousands of these for clients. We do company compliance and maintenance for over 10,000 business owners, where we're giving them legal advice in our law firm, KKOS Lawyers, and handling their business compliance needs, like their renewals or this new FinCEN requirement in our company called Main Street Business Services. So we know what this law is about. We know the requirement that has to be done. We've already helped thousands of clients do this. Now, in Alabama, there was a case that got filed against the federal government saying, hey, this law is unconstitutional. Now, this case was brought, and I've got an article on this. It'll be up on my website at mattsorensen.com. But this case was brought by a guy named Isaac Winkles. Isaac Winkles. I don't know. Winkles? That's the name. Guys, that's the name. And a trade association known as the National Small Business United, NSBU. Now, in the case, what they said was the federal government does not have the legal authority to legislate and require people who set up an entity with a state to then disclose the ownership to the federal government. They said that because the federal government, and we live in a federal government in a government structure where the federal government has limited enumerated powers. If you go back to your social studies class or your U.S. history and the U.S. Constitution, that's definitely taught in law school. I had to go through constitutional law classes on this, on the bar exam. We have a limited federal government. The federal government's powers are only what's specified in the Constitution. So a lot of cases that go to the Supreme Court under constitutional law, the primary argument is the federal government doesn't have the authority to legislate this because they weren't granted that power under our Constitution. So when our Constitution was first set up, the states had all the powers to legislate and make laws. The federal government only had the powers that the Constitution specified. Now, this has been something that's always litigated in the Supreme Court. A big piece of the cases going to the Supreme Court are about this one topic. Does the federal government have the authority to legislate this? Now, that was what Isaac Winkles brought and the National Small Business United brought as their case to say the federal government does not have authority because this is not something specified that meets some federal government interest. Now, the federal government's response was, of course, this is a federal government interest. We are trying to limit money laundering, criminal activities that happen across state lines. It's called the Commerce Clause. And so their argument was, no, we have plenty of government authority here. We need to know what's going on to make sure there's no federal crimes being committed, which money laundering is a federal crime. So we're requiring this disclosure to happen. Now, the judge in the Alabama case, Judge Burke, did not agree with the federal government and sided with the small business owner and said, actually, the government does not have a federal interest in this and struck down the law as unconstitutional. Now, it's really interesting. And this case is, by the way, it's going to go to the Supreme Court. I'm going to go through the process here later on to talk about what are the next steps in this case. But this case is going to end up in the Supreme Court, and that's where it's going to get decided. This was the opening remark in the opinion of the court. The judge said, the Constitution does not allow judges to strike down a law merely because it is burdensome, foolish, or offensive. Yet the inverse is also true. The wisdom of a policy is no guarantee of its constitutionality. Even in the pursuit of sensible and praiseworthy ends, Congress sometimes enacts smart laws that violate the Constitution. This case, which concerns the constitutionality of the Corporate Transparency Act, illustrates that principle. I mean, this is like Constitutional Law 101. This is like this opinion's so well written, actually, too. And that's where the judge started out, and you know where the case is going to go after it starts like that. He struck down the law saying the federal government does not have the authority to legislate in this area and to require entities that people create with the state. Remember, when you set up an LLC or corporation, you're not creating that with the federal government. You're creating that entity at the state level, and the states get to determine what information you disclose to them or have to file with them, not the federal government. So this is in the opinion of the judge in this case, an overreach of the federal government's authority. Hence, the law was struck down as unconstitutional. Now, what's happening now? What's happening now in the case? And by the way, I'm going to go over what should you be doing. Like if you've got an LLC or corporation, and this case is now ruled the Corporate Transparency Act as unconstitutional. Well, what do you do? I mean, you're not this small business owner in Alabama. Should you go bring your case? Does this case apply to me? I'm going to get to that here in a minute about what this means for you as the LLC or corporation owner. But let me go through the process of what's going to happen with this case. This case will go to an appeals process. The federal government is appealing the case. Now, this will go to a federal appeals court. It might be fast-tracked immediately to the U.S. Supreme Court. It's possible sometimes for a case to skip the appeals court immediately and go right to the U.S. Supreme Court. Because this law affects millions, tens of millions, there could be 100 million people affected by this. Because it affects so many people, this could get pushed directly to the U.S. Supreme Court. Now, what the typical path is, we don't know where it's going to get fast-tracked to the U.S. Supreme Court, but it'll go to the Federal Court of Appeals. And then I'm telling you, no matter who wins at the Federal Court of Appeals, whether it's the small business owner or whether it's the federal government, it's going to get appealed from there to the U.S. Supreme Court. And that will be the final determination of this case. There won't be any more legislation about this. The president can't veto it. This is going to come right from the U.S. Supreme Court, who will be deciding this case. All right. Do we have a question there, Tristan? Tristan's holding the mic. I don't know if that means he's got a question.
We do have a question that just came in. If you want to take a second for answer a question. All right. So Anime BZ said, should I wait to file with FinCEN until all these lawsuits are decided?
Okay. Now you see, I'm going to get to that. Right. That's a great question. I think you should still file. Now, here's why. The federal government in this case said, hey, the federal judge deciding the case said, this opinion only applies to the plaintiff in the case, this Mr. Winkles, and anyone who was a member of the National Small Business Unit before the decision was created, before the decision was entered. So they didn't want people saying, well, I'm a member of this association. They go sign up and pay the association fees. It only applies to the business owner that was a plaintiff in the case and anyone who's a member of the National Small Business United, National Small Business Association. Now, there's 65,000 people who are members of that. So those people can chill. They do not have to file. They can wait. Otherwise, the opinion doesn't apply to you. You are still required to file this. Now, let me get into the Corporate Transparency Act, because some people might say, but Matt, I'm going to wait it out. I know you're telling me I got to file, but I'm going to wait it out. Now, that could be a good strategy for some and a terrible strategy for others. If you are someone who set up an entity before 2024, under the Corporate Transparency Act, you have until January 1st, 2025 to file. You don't have to file this BOI report to FinCEN. Frankly, it's not due for another 9 months. So if you are someone that had an entity before 2024, you could say, I'm going to wait this out. Maybe I'll see how the appeal goes and if this gets fast-tracked to the U.S. Supreme Court. And that would make sense. I get that, someone taking that opinion. Now, my personal legal opinion about this, don't rely on this as just my YouTube opinion here, but from my experience as a lawyer, I think this case is going to get overturned, even though we have a pretty conservative Supreme Court who believes in limited government powers. I think this federal judge is going to get overturned in the U.S. Supreme Court, and this law will go into effect. That's my assessment of it. Not a constitutional lawyer. There's differences of opinion on it, but that's my sense of it. I could be wrong. But if you're like, Matt, I really don't have to file this thing with FinCEN. I really don't want to disclose this to the federal government. That's none of their business. I think for anyone that has an existing entity before 2024, you can wait it out. You got 9 months to see how it's going to go. And if it's not looking good in November, December, later on this year, you could decide to file at that point. I think that's a sensible approach. Now, for everyone else setting up new entities, you set up an entity last week or last month. You set up a new entity in 2024. You have 90 days to file this BOI report, or you're in violation of the law, which is up to $10,000 in penalties or 2 years in jail. If you do not file this thing timely, and you have 90 days from any new business entity from January 1st, 2024, from on, If you don't file that, you could face those penalties. So I would want people to comply with this. You're not subject to the court's order. So you're going to have 90 days to file. So for everyone else, and even any new entities we're setting up in our law firm, we are automatically filing this right now because you have to. You don't have a choice. And if you don't file it within 90 days, you go to jail or have tens of thousands of dollars in fines. So so that's kind of the downside for any new entities. But like I said, existing entities before 2024, they had until January 1st, 2025 to stay in compliance. So you get a little more time to wait this out and see how the courts are going to decide how the appeals process is going to work out. All right. Now that cut right to my question of what I wanted to tell you guys. I think for everyone who has prior entities before 2024, you do have some time. Now there's going to be a mad rush. We've already seen this with our own clients. Even before this case came out, it's kind of like, when do you file your tax return? On the deadline, or the month leading up to it. There's going to be a mad rush of people filing to comply with this in November and December, and we know it. So if you don't want to deal with the mad rush, go ahead and just file. Now here's what needs to be filed. I don't think people should be freaking out about this as much as they should. Frankly, the federal government knows who you are from your taxes anyways. If you're a good law-abiding citizen, why should you care about this? The federal government already knows that when you get your EIN. When you file a business return for the entity, they already know that. If this income is flowing from the LLC on your personal return, they already know who you are as the owner of this entity. And this BOI report that goes to the federal government under FinCEN, this BOI report is private. The federal government does not share this information publicly. Under the Corporate Transparency Act, when FinCEN receives your BOI report, they cannot share it except with other federal law enforcement agencies or state law enforcement agencies. This is not information available to the public. I know a lot of people are familiar with their LLCs they file with the state, and you can pull up anything on the state LLC or corporation filing, but that is not how this FinCEN filing works. This is not searchable. It's not a database anyone else can get into except for law enforcement agencies. So it's not like this information is going to be publicly available, what you file on the BOI report. Now, would I rather this law not be in existence? Yes. But do I want to advise my clients to roll the dice or wait and see on the case? Maybe if you had a prior entity, wait until the end of the year to see how the appeals court process works out. But for anyone filing new entities, or for most clients, and frankly myself, I'm just filing it and getting it done anyways. Even my stuff I did before 2024 hit. Even all those entities I had before with that, I'm filing just to get them in and get them done. Now, again, the Supreme Court could rule this and take it down and say, agree with the federal judge here in Alabama and say the law is unconstitutional. And that could be the case, And what's the worst thing? I end up filing and disclosing this to FinCEN. I don't know. It's not the end of the world. So everyone gets to make their decision on that. So that's the nice thing. I do think any of you new entity owners, though, you don't really have a choice because you only got 90 days to file. Existing owners, you can wait till the end of the year, see how the case sorts out. Okay. I think I made that point enough.
Yeah, definitely. Anna just wants to know, can her accountant file this form?
Excuse me. Yes, but most accountants are not filing this. This is a legal filing. And so a lot of accountants aren't handling this. We actually get a lot of our business from accountants. We handle this at our company called Main Street Business Services. We'll drop the link in there, mainstreetbusiness.com. We are filing these for clients. We're doing your state filings, your annual minutes. There's a lot of other services we provide there, but we will handle this FinCEN BOI filing on behalf of your entity, no matter how many entities you have. So if you go to our Main Street Business Services, you can book a call right there with one of our compliance specialists, and they'll go over the filing requirement, what they'll need from you. But here's what you're going to need to file. Remember, for any entity, you need to file this. It just goes anyone who owns 25% or more and anyone who has substantial control of the entity. This could be the manager of an LLC, president of the corporation. So any of those people have to be listed on this BOI report. And it's an online filing. You can file it at fincen.gov yourself, or you can engage a company or a law firm to do it. We also do them in our law firm for all of our new entities we're setting up. And then also we're doing it if people just want a one-time filing. They don't want to be on an annual service where we're doing your annual renewal, updating your FinCEN filing. By the way, if you move or do any changes in ownership to the company, you have to update your FinCEN filing and file an amendment as well. So you have a new BOI report. If there's changes to the company in the ownership, the name, you move your address as one of the owners, you have to update that and do an amended BOI filing. So we handle that too in Main Street Business Service. But this is something you can do on your own. If you want to do it on your own, it's fincen.gov. You can file it online, or you can hire a professional to do it, whether that's us or one of our companies or someone else. There's other places to go get that service. All right, another question coming in. I'm going to have some of the questions that came in already. Let me hit some of those. And then Tristan, you just interrupt me when you have anybody live that has a question, because I'm going to prioritize any live questions. But these are some of the ones that we had come in already. Pat asked, what about offshore LLCs and LLCs that are established offshore? BOI does not apply to offshore LLCs, but you've got a lot of other stuff you're filing to the federal government instead of that. So you're filing something called an 8938. This is a foreign asset report that would include any LLCs or corporations. Also, if you have a bank account in that LLC offshore, you have to be filing an FBAR report, a foreign bank account report to the federal government. So if you have any foreign entities, your compliance requirements are 10 times this BOI. The BOI is a very simple, easily filing. Any of you with foreign corporations or entities, you have a lot more reporting you got to be doing to the federal government. And you do not want to mess around with that. So any of you guys that have foreign entities, make sure you're talking to competent counsel about what to be filing. We do have some international lawyers in our law firm, KKOS Lawyers, that can help advise on that. But don't be messing around with the offshore stuff. That's even worse than messing around not doing the BOI with the U.S. entity. All right, Kay asked, do I need to do this for an expired LLC? For an expired LLC, it depends. So under the law, the Corporate Transparency Act, it says any entity that is inactive before and was set up before 2020, you do not need it. Sorry. Any entity that was inactive and was set up before 2020, you do not need to file the BOI report. Okay. So if you've got old entities out there, something you set up in 2016, you haven't used it, there's no money, no transactions that have happened in it, don't worry about it. You don't need to file the BOI report for that entity. Now, I still think you should dissolve that entity and close it out and clean it up, but you don't need to worry about a BOI report. But let's say you set up an entity in 2021 and you're not using it right now. Well, you still need to file the BOI report, okay? So it depends on where the expired or inactive entity is, but there is an exemption for that. It's called the inactive entity exemption, and it just depends on when you set it up. 2020 or before, don't worry about it. Anything after 2020, even if it's still inactive, you have to file. All right, we had a question from user RL4HL3. Says, does this apply to a sole proprietor LLC for a business or general partnership LLC? Yes and yes. It applies to both. It doesn't matter if the LLC is a sole proprietorship or taxed as a general partnership or an S corporation. Every LLC has to comply with this. The only exceptions, I mean, if you're like a bank or a credit union, there are some exemptions for like certain regulated entities where you've already filed a ton of stuff to the federal government, by the way, instead of this. But the only exemptions for LLCs are the inactive one I mentioned, and these are the ones that are really practical. And then any entity where you have 5 million of revenue or more. If you have 5 million of revenue or more, the federal government's like, you don't need to file this. We already track you and know who you are. It's kind of like the large business exemption. So, which kind of sucks. I don't like that one because it kind of is punishing small business, and all the small business owners are the ones that have to comply. The big businesses get exempted, but that's the law. Write your congressman or senator if you don't like it. So, but sole proprietorship or general partnership, it doesn't matter. If it's an LLC established with the state, you got to file this BOI report. Again, remember those two exceptions, that are the practical ones: over 5 million in revenue or the inactive entity. All right, another question from Daniel. What if the LLC has 4 people total and the reason for the LLC was to protect an inventor on patent of possible liability issues? They don't care what the reason, Daniel, for setting up the entity was. The federal government could care less. If those owners are all equal owners, 4 owners in an LLC, all equal, owning 25% or more, every one of those is going to have to be on the BOI report. And you have to disclose their name, their date of birth, their address, and provide a government-issued ID to file that BOI report for that LLC. Now, I don't know if one of those people is the manager of the LLC or there's someone else that's the manager of the LLC, but that person has to be on the BOI report as well. So sorry, Daniel, you're just going to have to file that. And again, if you guys are all equal owners at 25%, then you're all going to have to file. Now, let's say that let's take that LLC example though. And let's say that it was 2 investors have 30% in the LLC and the other 2 have 20% for a total of 100%. Well, the 2 that have 30% would have to be on the BOI report because they're 25% or greater. But the 2 that were 20% don't have to be on the BOI report. Okay. So anyone below the 25% that doesn't have control in the operations, they're not the manager or anything, they don't have to be on the BOI report. So that's the threshold is 25% or greater.
Matt, what if you have a DST?
Okay, a Delaware statutory trust. So trusts do not have to be, unless they're filed with the state. So there are some type of states like business trusts, Delaware statutory trusts. I'm not sure if there's a filing to the state. Frankly, we don't like clients using Delaware statutory trusts as individual investors. We think that's an overhyped strategy. That's another topic for another day. But only entities filed with a state where you get a state approval back, do you have to file? Does that then mean that this BOI report in FinCEN? So for example, any LLC, you file it with state. Any corporation, you file with the state. Business trusts, if you're doing a business trust, and some states have a business trust where you actually make a filing to the state, those you'd have to do a BOI report. Delaware statutory trusts, I have to look that up. We just don't recommend them for clients here because we think they don't work for individual investors. They're more for larger organizations is generally where we use them. I'm not sure if you actually do a filing to the state in a Delaware statutory trust and a DST. But like your revocable living trust or land trusts, those aren't stuff that are filed with the state. So that would not be anything you'd file a BOI report for. Now, one of the tricky ones is a series LLC, because a series LLC, you file one LLC at the state. That's kind of like the master LLC or the main LLC. And then you have the subseries LLCs. In the subseries LLCs, in some states, you don't have to even say what those subseries are, and there's nothing filed to the state. So in those states, you just file the master LLC, would do a BOI report, but all of the subseries LLCs, there'd be no FinCEN filing to the state. Now, some states do require, like Texas, that you get a name and there is a filing to the state. Illinois is another state that has series LLCs where you have to then also give notice and do a filing for each subseries. In those states where with series LLCs, you would need to do the BOI report. So that's going to be a state-by-state basis, like let's say Utah, for example, that has series LLCs, or even Delaware for that matter. You do not file the subseries with the state. You adopt it in your internal documents. In those states, no BOI report for the subseries. That might be a little bit in the weeds for some of you, but in either series LLC, we've had a lot of questions on how to do those.
I keep seeing this question pop up, Matt, and I know this might just need a little clarification, but I keep seeing this. Anna mentioned this is not for S corps, right?
Oh, I wish that was true. Yes, this is for S corps. If you have an S corporation, you've got to file the BOI report too. A C corporation, an LLC, taxes a sole proprietorship, an LLC taxes a partnership, an LLC taxes is an S corporation. They don't care. If it's any entity created at the state level, a BOI report needs to be filed. And so all of you S corp owners, and we love S corporations. I have an S corporation. We recommend them for all of our small business owner clients making at least 40K net that are selling goods or services. You should have an S corporation, but you're still got to file the BOI. I know a lot of the media that's been going out on it and the conversations in social media are, you got to do a BOI report and this FinCEN filing for LLCs. It's for corporations too. All right. So all of you S corp owners, you're going to need to comply with this too.
And I know you've already touched on this one, but we're just going to go ahead and throw it out here.
If the questions are coming, let's go. I got some more of the pre-ones here too as well. Thanks guys for asking all the questions too.
Yep.
That's what I'm here for. Ask.
And so we know this one, the extroverted accountant threw this one in here. She says, if you had an active entity going into 2024, then dissolved it before filing the initial BOI, do you still need to file the initial report, then the subsequent update saying it was dissolved?
Okay, great question. So if this was an entity set up before 2024, Okay. So an entity set up before 2024, the BOI report isn't due until January 1st, 2025. So you have the full year to do it. If you dissolve it now, your deadline to file hasn't approached yet. So our position has been you don't need to file a BOI report. And what we've been doing with a lot of our clients in our law firm, we've done hundreds of dissolutions. We've been cleaning up clients' crap like crazy and saying, get rid of all these entities you're not using anymore. That old LLC or that business you shut down that you just kind of like left on the side and didn't really get rid of it properly, dissolve it, get rid of it now, even here in March of 2024, because you will not have to file the FinCEN BOI report. So I don't think you got to worry about even filing it. You're cool, but you got to get it dissolved before the end of the year, which is when the filing deadline hits. So if you let that entity creep into 2025, you got to have it filed. So file or dissolve, you got to decide here in 2024. Now, for any new entity that you set up, let's say you set up an entity in January and you're like, if that business isn't going to work out, I don't need to do it. You still need to file the BOI report. Okay. I guess if you dissolved it within the 90-day window, you could get out of it. But I think that's going to be very rare where someone sets up an entity and knows they want to dissolve it within 90 days, which is the filing time. So, but all you existing business owners, just dissolve. Don't worry about the BOI, but make sure you get it done before the end of the year.
And Karen, that question there, it's the beneficial ownership information, and the page is fincen.gov/BOI.
Yeah. BOI, beneficial ownership information. That's not your body odor index. That's something else, which I'm pretty low on the BOI index. I don't know. Maybe I'm high. Okay. I got another question here that came in. Let's see. Do foreign LLC owners have to file this? Non-U.S. residents? Yes. If it's a U.S. LLC, you need to file it. Now, for anyone who's a non-U.S. citizen, you need to provide the same information, your name, address, date of birth, and then you need to provide a form of ID, whether that's a state government issued ID or a foreign passport. So you could use a foreign passport as your form of acceptable government ID. Now, any of these photo IDs, though, you have to understand they have to be they cannot be expired. So we've ran into some situations already where people are like, well, I haven't updated my driver's license. Well, go do it. You don't have a choice. My passport's expired too. Well, what do you have? Nothing. We can't file anything yet. So you might have to update that if you do have expired. But foreign residents that have U.S.-based LLCs or corporations or other entities, you got to file too. And in fact, I hate to say it, but the federal government's more interested in that scenario. So make sure you're definitely complying with that. Robert asked, does this affect sole proprietors like handyman or contractors? Robert, maybe. It depends. Does that handyman or contractor have an LLC or corporation? If they do, then yes, it does affect them. But let's say you're like, I'm just a sole proprietor. I don't have any LLC or corporation. I'm just doing business in my personal name. Do I need to file the BOI report? No. If you have not created a corporation or LLC, you're just a sole proprietorship. Maybe you have a DBA or something like that. That is not an entity. Okay, that's just a name reservation. And so you do not have to file the BOI report, but any LLC or corporation, limited partnership, trust that you file and get approval with the state, those you're going to have to file the BOI report. But just a sole proprietor on its own with no entity, no BOI report required. All right, Brandon asked, is this a one-time filing or does it have to be done annually? This is a one-time filing, Brandon. So you've got to file it once to disclose for every entity. Again, anyone 25% or more owner that has substantial control. You only have to update that if the information changes. The name changes, the ownership changes, the address of one of the people on the BOI report changes. Those are scenarios we're going to have to update the BOI report and file an amended BOI report. But there's no annual requirement to file anything to FinCEN. It's kind of a one and done. Then you just update it if there's been a change. All right. Dervin asked, so the deadline is December 31st, 2024 for LLCs formed before January 1st, 2024, or did I have that confused? So, yes, that is correct. You do have that right, Dervin, is December 31st, 2024 for entities filed and set up before January 1st, 2024. So if this was an entity set up in 2022 or 2015 or whatever, you have until January 31st, 2024, the end of this year, to get the BOI report filed. But if you set up an entity in February of 2024, you have 90 days. Okay. You do not have until the end of the year. Any new entities set up in 2024, and this is the new rule moving forward from here on out, you've got 90 days to file this. Now, remember, for any of you that are like, Matt, I have my entity I set up in 2020 or 2019. I've been using it since. I want to see how this case turns out. The case was ruled unconstitutional. Remember, you could do a wait and see approach. You could say, Dervin, in your question here, I'm going to wait and see how this case, I'm going to wait till November, December of this year to see if I even need to file it in the first place. Maybe the small business owner is going to go all the way to the U.S. Supreme Court and win the case, and I wouldn't have to file this thing. You could wait and see. It's going to be chaos for all of us trying to help people file these at the end of the year because of this case, but I understand that, and I understand someone wants to take that position. But remember, for any of you people that just recently set up LLCs, you have 90 days. Wait and see is not going to work. There's just not enough time. The case is not going to be adjudicated. The appeals will not be done within 90 days. You do not want to be in a situation where there could be criminal penalties or fines or anything like that. Just make sure you're getting it filed if you're setting up entities right now. All right. Any live question there, Tristan?
Yeah. I got someone on LinkedIn asking what ID would be needed if an LLC partnership has a foreign company as a partner?
Okay. If you have a foreign entity as a partner, then you have to go down to the owners of the foreign entity. So you kind of got to break that up and say, all right, the owners of that foreign entity are these people, and then anyone that owns 25% or more of that. So any entities that own an entity, you're going to have to kind of go to the underlying owners to disclose who those people are. And that's kind of part of the purpose of this is FinCEN wants to know, they don't want all these shell companies out there that don't know who the heck owns them. They want to get to the underlying beneficial, that's the B in the BOI report, the underlying beneficial owners that have significant ownership, 25% or more, or that have a, who has substantial control. That's the manager, president of that. Now, if it was a US-based LLC, that entity would have already filed for a BOI report. And so you'd be able to rely on that was already filed. But for a foreign entity that likely not going to have a BOI report, so you have to break down the underlying owners of that on the US entity's filing. All right, what else? Got anything else live? Okay. All right, we had, this was from Terry. He said, what if there are 4 equal partners, each holding 25%, yet there is no manager? Does each partner have to file a form, or is it just one form for the LLC itself? There are no employees and, frankly, very little revenue. So, Terry, in that scenario, you have one BOI report. So every owner doesn't file their own report. It's one BOI report for the entity. So the LLC in this situation, there'd be one BOI report that would list each of those 25% owners, their name, address, date of birth, and provide a photo ID. Now, in that instance, it sounds like you have what's called a member managed LLC where there's no manager. The members collectively manage the LLC. We don't really love that. Just, we always do manager managed LLCs because at the state level, you don't have to disclose who the members are. You just disclose the manager. But if you're doing member managed here on your LLC filing, you would have had to list each one of those members with your state LLC filing. So that's public. That's on a state website. So we don't love member managed. But anyways, you already have that, Terry. To answer your question, one BOI report listing all owners. Now, if you do have some owners that are like, I don't want to share my information with those other owners of the LLC, you can. There is a process where you can create a FinCEN ID for an individual where you go in and log your own stuff individually yourself, and then you share that ID with the company, and they will use that to then upload on your behalf to say, and this person also owns 25%. But you would have had your own information you already provided to FinCEN individually that could be separate. We haven't seen that used a lot, but if there is people in that scenario where you have business partners, which frankly, you should be willing to share that information. I don't know why you business with someone if you didn't, but I get it. Could happen. There is a way to do it privately and file it yourself and then provide the ID identifying information over to the person filing the BOI report for the LLC.
We have another common question. Callaway Vacations is asking, is there a fee for filing BOI?
Okay, that's the good news. There's no fee. If there is any good news in this, at least there is no filing fee. You'd think the federal government would try and get something out of this besides just the information, but no filing fee to file the BOI. Now, there are companies helping do it. I just say for us at Main Street Business Services, we charge a fee if we do it for you. It's part of our company compliance program where we do your annual renewal, we do your state minutes. And in that instance, it's $200 a year, but we're doing that every year for you. It also includes updating the FinCEN BOI report if you have any changes to it. Our law firm's $250 just to do a one-time filing. So there are other services that charge a fee, but if you do it yourself, there's no filing fee or there's no fee at the federal government level. There's just a fee if you're paying someone else to do it on your behalf. All right. We hit all these live questions. Okay, here's the question from Rupak. He asked, FinCEN requires U.S. company addresses and tells me not to use a virtual office. I'm a non-resident and use Northwest Registered Agent address for incorporating and obtaining EIN. What address should I use for BOI? Well, on the BOI, they want personal addresses of the individuals. They don't want the company address. They want the individual owner addresses. So that would be your actual place where you physically live and reside. Sorry, you may not like that. And I know a lot of people are like, I don't want to give my address out. This is, again, not going to a state website. This is going to the federal government. Same thing when you're filing a tax return, you're dropping that on there also. So they want an actual personal residential address, whether that's in the U.S. or not. So now the company can have an address, and that could be an address service or an office address, someplace you lease. That's fine. That's fine to use. I'm not aware of that not being okay. But for the BOI report for the individuals, which is really where you're just laying out the addresses, that should be the residential address of the individual owner. All right. All right, Loverboy, good handle. Okay. Loverboy says, what if the state dissolved the LLC, but you still have the EIN? Okay, if you did a dissolution of the LLC, but you didn't close out the EIN, I would do one thing, which I was close out the EIN. Now, if the LLC had was an S corporation or a partnership, the way to close out the EIN is when you do your final tax return for the entity, there's a box you check. So your S corp return or your LLC partnership tax return, there's a box you check to say LLC's been dissolved. This is the final return. That closes out the EIN. Now, if this was a sole proprietorship, though, and it was just flowing on your personal return, there was no partnership return filed for the LLC, it was not an S corp, what happens in that scenario is you need to send a letter to the IRS. Now, there is an actual website. If you go to, the IRS actually has an address where you file these and send these letters. It's basically just a letter you send to the IRS saying, I've dissolved this LLC. Here's the EIN. Here's a copy of the state dissolution. Please close out the EIN. And that gives the IRS notice and they can close out the EIN. We recommend doing that. We do that on all of our dissolutions now. We didn't always do that, but now because of the BOI report, we want the IRS, the Department of Treasury, which is where FinCEN sits, we want them to know that this EIN and this LLC is not around. Because what do you think FinCEN is going to do next year? They're going to go send letters and pull out the people that didn't file this. And they're going to go pull it by EIN and say, who filed this? If you have an active EIN with the IRS and you didn't file this, you're going to get a letter from FinCEN next year. I mean, that's probably what they're going to do, and it's not going to be hard to do. So we want to close that out. So what I would do, if you just go to IRS, if you just search irs.gov, to closing out EIN, there is an address. I don't know if we have it. I've had it at one point. I just don't have it handy right now. We might be able to share it in the chat here in a second. But there's an actual address where they want you to send the letter to dissolve and close out an EIN.
All right, we got a question from YouTube. If I have an SDIRA that has a single member LLC, who goes on the report?
Ooh, good question. We have lots of clients that use LLCs owned by their IRA, and they're doing self-directed IRAs. We got in our company directed IRA all the time. Love that strategy. People buying rental real estate, investing in small business, doing private money lending with their IRAs, and they use an LLC here in the middle. In that instance, you have to go to who is the beneficial owner of the IRA. Well, during your lifetime, you're the beneficial owner of your IRA. So you're the one on the FinCEN BOI report for your IRA LLC. So it's really going to look the same as your regular LLC. The IRA is there, but for purposes of FinCEN BOI report, they want to know the beneficial underlying ownership, which is going to be you personally. So whenever there's an IRA, HSA, Roth IRA, even solo K, we're going to go to the underlying owner of that, which is the owner of that account. All right. Lisa asks, what if you have a simple will, not a trust? Do both spouses have to be listed? No, they don't have to be. I presume what Lisa meant here is you own the LLC, not your trust. A lot of people will have their revocable living trust own their LLC. The LLC owns their investments or rental properties, and that's very common. Or the LLC owns the operating business, selling goods or services. That's very common. We want your trust, your revocable living trust, to own your assets. It should. Okay. That's how it avoids probate, and that's how your estate plan happens, and everything passes how you want it to. If you don't have a trust, but you just have a will, then the ownership of the LLC is whoever you listed when you set it up. So what you want to do is look who is listed on that LLC when you set it up, which spouse, and generally their social was used to get the EIN. It's usually flowing onto your tax return as this person is the owner. That's who you should list as the beneficial owner. Now, I know in community property states, stuff like this, it's joint marital property anyways. You both own it, but don't get too technical about it. If you just filed an LLC or corporation with you as the owner, or your spouse is listed as the owner, just list that person on the BOI report as the 25% or greater owner. Now, on the other hand, if you do have a trust, a revocable living trust that specifies this is a joint trust, this is me and my spouse, and the trust owns the LLC, both of you would be listed on the BOI report because you are both beneficiaries and owners of that trust, which does own the LLC. I was going to say, in effect, it does own the LLC. So little nuance there in terms of anyone owning a trust. Now, remember, we are going to be back here every Monday going over topics applicable to building wealth, small business ownership, rental and real estate, using real estate to invest on a short-term, long-term basis, building and growing your retirement account. And we're going to be talking about how to max out your retirement accounts, not your credit cards here. We'll also go over how to grow your income in careers. There's lots of different ways to build and grow wealth. I do not believe there's just a get-rich-quick scheme. I've just had the 10,000 hours with clients. I've seen people build wealth. I've seen the clients come and do their estate plan, want to get financial planning advice, want to talk about protecting their assets that they built over time. They have wealth. It's not rocket science on how they've built it. They're doing it the old-fashioned way. They're working hard. They're saving more than they spend. They're maxing out their retirement accounts. They're building a rental real estate portfolio. They're owning small businesses. That's it. That's it. I mean, it's not more complicated than that. It's hard to do, right? There's work. You got to be disciplined. But we're going to be talking about that and all the strategies that go into that, making sure you're saving on taxes in the process and only paying what you have to, making sure you're protecting your assets, that you're planning your estate for your loved ones. Do you have a good strategy on your investments? That you're knowing how to use your retirement accounts properly, that you're structuring your investments in the best and optimal way, that you're doing your due diligence when you're getting into business or making investments with others. There's all this stuff we're going to be talking about here at Team Wealth Building. So make sure you're subscribed to the Facebook page. Get over to the Facebook private group and make sure you go sign up for it. We're going to be dropping a lot of content in there. Make sure you're subscribed to the YouTube channel. Again, we're going to be going live here every Monday at noon Pacific time. And if you have topics that you want, please share those in the private Facebook group of upcoming topics. We're going to be talking about the backdoor Roth IRA coming up. We're also going to be talking about the new law that just passed from Congress. There's new tax rules already. It just happened last week. I can't believe it. I'm barely getting my head around the Corporate Transparency Act. And now there's some new tax laws that passed. So we'll be talking about those as well in the upcoming lives. And we're going to have topics you want to talk about. We're doing case studies of individuals that have built wealth, and also be giving tutorials and lessons on how to make a financial plan and budget for your personal situation. So we'll be back next Monday. I don't know if we have any final questions, Tristan. We haven't filled it yet. Okay, we'll be back next Monday at 12 Pacific. Make sure you're subscribed to the channel and you're participating in the private Facebook group, and we'll see you back next week.